All right. Once again, good day, ladies and gentlemen, and to my fellow colleagues. Today is the continuation of this informative session hosted by the Unisa Law Clinic about wills. My colleagues previously, Mr. Sifiso Mahlangu and Ms. Khupucho Lipepe, have touched on what a will is and the importance of having a will, as well as the difference between dying without a will and having a will. Today, my duty is to talk about the requirements of a valid will. The formalities of a will are governed by the Wills Act 7 of 1953, and as such, the requirements of how to make a will are governed by under sections 1 and 2 of this act, and are as follows. Number 1, a will must be made voluntarily. If someone is coerced to make a will without him showing the true testament of his will, that will then be determined to be invalid. So you cannot coerce someone, you cannot bribe, you cannot do anything when someone by making someone make a will without showing his true intention of doing that. Secondly, a will must be reduced to writing. No oral will. There's nothing as such. So there's no oral will. So a will must be reduced into paper and be signed. The third part is that a will must be signed at the end of the last page by the person making the will, who is called a testator. So if someone is making a will, is signing the page, if we've got more than one page, the person who is making the will should initial every other page except for the last page. The last page is the page where the testator signs. Secondly, if someone is unable to make a will, to sign, some other person under the presence and direction of a testator, when is making a will, should be done in the presence of a commissioner of oaths. So it can so happen that someone is making a will, that person is unable to write, say in an unfortunate incident when someone doesn't have limbs or something like of that sort, then that will should be done under the presence of a commissioner of oaths, who will then confirm the identity and the will of the person making this will. The fourth part is that a will should be done under the presence of 2 or more competent witnesses who must sign on the last page of the will. So what qualifies someone to be a competent witness? The person must be 14 years or older. The person must be 14 years or older, and the witness must have the legal capacity to appreciate appreciate the acts of being a witness, and will be able to go to court and attest to such. So those are the essential parts of what make a will to be valid. So the will must be made voluntarily. The will must be reduced to writing by the testator, and a will must be signed at the last page. If a will has 1 or more pages, or so rather has 2 or more pages, The will then, so someone, the testator must then must initial each page except for the last page. The last page is where the will only sign with the witnesses at the last page, and the witnesses must be someone who's 14 years or older and must have the legal capacity to appreciate that he or she will give evidence in a court of law attesting to such. So it's those four requirements that is really required to make a will. And in conclusion, making a will is required by the Wills Act, must be adhered to, and as failure to do such, that will invalidate a will. In our next session, which will be on Wednesday, the 16th of August, the question and answer sessions shall be done by Miss Keisha Martinez. So thank you guys for tuning in. I hope you learned a thing or two.